I want to explain what the new Texas eviction law that takes effect in 2026 actually does and why tenants should be concerned. I'm not going to sugarcoat this. This law fundamentally shifts power toward landlords and makes it easier and faster to remove people from their homes. 1. This law speeds up evictions and shrinks tenant protections. The biggest change is speed. Eviction cases will move faster, with tighter deadlines and fewer opportunities for tenants to prepare or defend themselves. That might sound neutral, but it's not. Speed always favors landlords, because landlords file these cases every day and usually have lawyers. Most tenants do not. When cases move fast, tenants miss deadlines, don't know what documents to bring, don't understand defenses, and don't have time to find legal help. Faster evictions mean more people losing housing before they ever understand what's happening. 2. Tenants are being forced to take legal risks just to appeal. Under this law, if a tenant wants to appeal an eviction, they must swear under oath that the appeal is not being filed just to delay the case. That sounds harmless, but it isn't. Most tenants are not lawyers. They do not know whether a judge will later decide an appeal was valid or just for delay. This puts tenants at risk of being accused of lying under oath simply for trying to protect their housing. Landlords face no similar risk for filing weak or aggressive eviction cases. The risk is one-sided, and it discourages tenants from appealing even when the eviction is wrong. 3. Eviction courts will still ignore unsafe conditions and retaliation. This law keeps eviction courts focused almost entirely on possession, not fairness. That means if a landlord failed to make repairs, ignored mold, plumbing issues, or safety hazards, or retaliated against a tenant for complaining, the eviction court usually will not hear it. The tenant is told to file a separate lawsuit later, but later often means after the tenant has already been evicted. Once someone loses housing, separate lawsuits become unrealistic. This law rewards landlords who ignore their responsibilities and file eviction first. 4. Electronic notices create serious problems for tenants. The law allows eviction notices to be sent electronically if the tenant agreed to it in writing. That raises serious concerns. Emails get lost, messages go to spam, people change addresses. Tenants may not have reliable internet access, but courts tend to accept proof that a notice was sent, even if it was never actually read. That means tenants may miss critical deadlines without ever knowing a case was filed against them. 5. This law makes evictions worse during disasters. Texas experiences hurricanes, floods, freezes, and power outages. Under this law, courts and local governments lose flexibility to pause or adapt eviction procedures during emergencies. The eviction process keeps moving even when people are displaced, power is out, or courts are barely functioning. That is not hypothetical. It will happen. This law ignores real-world crises. Timer 6. Unequal legal representation will decide outcomes. Landlords are repeat players. They know the system. They often have attorneys or professional property managers. Tenants are usually alone. This law increases complexity while shortening timelines. That combination guarantees worse outcomes for unrepresented tenants. When rules get stricter and faster, people without lawyers lose, even when they are legally right. 7. Federal housing protections may be undermined. Tenants in federally subsidized housing, including Section 8 and other HUD programs, have federal notice and due process protections. This law does not clearly account for those rules. That creates confusion and increases the risk that tenants will be evicted under state timelines that conflict with federal law. That leads to wrongful evictions and chaos, especially for vulnerable households. 8. There is no transparency or accountability. This law speeds up evictions statewide, but it does not require meaningful data reporting. There is no requirement to track how many evictions occur, who is affected, or whether displacement increases. If lawmakers were confident this law was fair, they would require transparency. They did not. 9. This is not just a procedural change. It changes outcomes. Supporters claim this law is just procedural cleanup. That is misleading. Procedure determines outcomes. When you shorten deadlines, limit defenses, discourage appeals, and remove flexibility during emergencies, more people lose their homes. That is the real-world effect. This law does not create new tenant protections. It removes leverage tenants historically relied on to survive eviction cases. Bottom line, this law makes evictions faster, harder to fight, riskier to appeal, and less forgiving during emergencies. It benefits landlords and repeat players while placing heavier burdens on tenants who already lack legal representation. Speed without fairness is not justice.